Welcome, everybody. Welcome to today's episode of the Law of Self-Defense Show, our Platinum member Q&A program that we periodically run. I am, of course, Attorney Andrew Branca for Law of Self-Defense. Thank you, thank you, thank you. That is all greatly appreciated. Let's take a look and make sure we're streaming everywhere we're supposed to be streaming. And it looks like we are. All right. And lastly, Rumble. Perfect. All right. So we have a bunch of questions we're going through. So in these periodic Q&A shows that we do every couple of weeks or so, I take questions from our Platinum members. So Platinum Law of Self-Defense members, in addition to being the only people entitled to my legal consult services, if they're ever compelled to defend their use of force in defense of themselves, their family, or their property, they also get a special Platinum member Q&A form on the website where they can submit questions directly to me, and I either answer them privately if they prefer, or they get added to the queue for one of these periodic Q&A shows. And so I've selected a bunch of questions from that list submitted using that form, and those are the questions we'll be covering today. Now, importantly, the way we run these shows is they typically last for an hour, maybe a little more than an hour, as we step through the questions, but only the first 30 minutes is an open stream on YouTube, Rumble, and Twitter. In fact, I have my timer running right now, down to 28 minutes now. Only the first 30 minutes of the show is open access. After 30 minutes, we cut off the YouTube, Rumble, and Twitter streams, and it's a members-only broadcast because this, of course, is live streaming also on our Law of Self-Defense member dashboard. The good news is it's dirt cheap to be a Law of Self-Defense member, only 99 cents. Folks, you could open up another tab on your browser right now, go to lawofselfdefense.com/trial, and for 99 cents, get a 2-week trial membership. You'll be emailed instructions for how to join us for the rest of the show, the members-only portion of this show and every show that we do. After 2 weeks, it's still dirt cheap. It's only about 30 cents a day to be a Law of Self-Defense member, less than $10 a month, folks. And you can take advantage of that opportunity for 99 cents for a 2-week trial at lawofselfdefense.com/trial, or scan that QR code there on your screen. With that out of the way, let's go ahead and launch the formal start of today's show. That was not the right one. Let's try that again. All right, and today's show is sponsored by the Law of Self-Defense itself in the form of our book, The Law of Self-Defense Principles. Check it out on Amazon. This is the guidebook to making yourself hard to convict if you're ever compelled to defend yourself, your family, your property. Check it out on Amazon, 5-star rated, best-selling in its category, but don't buy it on Amazon. Amazon will charge you for the book and the shipping and handling. Go to lawofselfdefense.com/free book, and we'll send you the book for free. We only ask that you cover the cost of shipping the book to you. That's lawofselfdefense.com/free book, or scan that QR code right there. All right, so the questions we're going to be going through today are, does an attached garage or an enclosed porch count as part of my castle for castle doctrine purposes? How is curtilage defined, and what does that do for me? If burglary justifies deadly defensive force, what qualifies as a burglary? How legally perilous is it to come to the defense of a stranger? What is an unpublished court opinion, and why does that matter? What is the burden of production, and who has it? How do I tactically manage being approached by a group of scary men? What happens if I shoot in lawful self-defense but hit an innocent bystander? Should self-defense instructors use a disclaimer when teaching about self-defense law? Just in case I ever need one, can you recommend a use of force expert witness? Should you have your lawyer, rather than yourself, call 911 in the aftermath of a use of force event? So That's just to give all of you an overview of what we'll be covering in today's show. Again, after 30 minutes, now down to 24 minutes, we'll be cutting off the YouTube, Twitter, and Rumble streams. The rest of you Law Self-Defense members watching on the dashboard, you don't go anywhere at that point, please. All right, so first one. Our Platinum member lives in Tennessee, just finished our Tennessee-specific Law of Self-Defense course. So we have a state-specific course for each of the 50 states, folks. You can get yours at lawofselfdefense.com/state. And this Platinum member had just finished our Tennessee self-defense course and had a couple of questions. He says, I have a brick garage that is attached to my house and was built with the house. I assume this is part of my dwelling. Is this correct? And the answer would be yes, that is correct. If it's attached to your home, it's part of your home. A detached garage can be more problematic. He writes, I have a back deck that was later converted into an enclosed sunroom with lockable doors into the house. Is this part of the house? Yes, it would be part of the house. Again, now it's attached to your home and particularly enclosed. If it was just an open porch, that might be more complicated. That's where we'll go into the next question about curtilage. The same member asks also, I might have missed it, but what is considered curtilage in Tennessee? Thank you very much. So, curtilage in Tennessee. Well, curtilage generally is a legal term of art that refers to the area immediately around your home that's part of the normal day-to-day use of your home. That's true in every state. So in that sense, we have some clarity in that states share the definition. But it gets more ambiguous because very few states have an explicit statutory limit on curtilage. So in theory, if you're standing on the stoop of your home, the stoop you go up and down to get into your house every day, that would be immediately around your home and part of the normal day-to-day use of the home, and that would be included within the curtilage of your home. But the further you get from the home, the more ambiguous it becomes whether or not you are still in your curtilage. Certainly, once you reach a place where you no longer have the right of exclusion, like a public street, that's absolutely not your curtilage. But as you progressively move from adjacent to your home towards that public street, at some point, have you left the curtilage of your home? Arguably, if you live on 40 acres, when you get to that 40th acre, it's not part of the curtilage of your home anymore. That's not part of the daily use of your home. Now, unless, of course, that's like the end of your driveway, then you could argue, well, I go up and down the driveway every day. That is part of the normal day-to-day use of my home, as opposed to it's, the woods out in back of your house. So you never really know if you're standing in your curtilage, because whether you are is going to be determined in a court of law well after whatever it is that you've done that involves curtilage. Why is curtilage important? Well, because often when a use of force law privileging you to use force under self-defense, defense of family, defense of others, defense of property, defense of dwelling, often it will provide special privileges for the use of force when you're defending while inside your home or within the curtilage. This also applies in the context of castle doctrine. Castle doctrine, properly understood, does one thing. It relieves you of an otherwise existing legal duty to retreat before you can defend yourself, if you would have had that duty outside. So if you would have had a legal duty to retreat out in the public street defending yourself, you're relieved of that duty to retreat if you're defending yourself in your home. And the curtilage is typically included as part of the castle for the issue of retreat. So if you wouldn't have to retreat in your living room, you also don't have to retreat when you're outside your house, but within the curtilage of the home. Now, not every state recognizes curtilage for castle doctrine purposes, and particularly Massachusetts. If you step 1 foot outside your doorway, there is no curtilage protection. There is no castle doctrine for you anymore. You have, and Massachusetts is a duty to retreat state. So you've just acquired that legal duty to retreat before you can defend yourself if you have even 1 foot outside your front door. No curtilage recognition for castle doctrine purposes in Massachusetts. So That's what curtilage is, and that's what it does for you in a use of force context. It can relieve you of an otherwise existing legal duty to retreat, even if you're physically outside the four walls of your castle. They also ask, how is, let's see, where are we? What is considered curtilage in Tennessee? Well, not every state does this, but Tennessee is very helpful in that they actually provide a statutory definition of curtilage within their self-defense statute, which I have helpfully prepared. So that is here. Let's see if I can make this bigger for everybody. Uh, 3911-611 is Tennessee's kind of foundational self-defense statute. And the first paragraph provides some definitions. As used in this section, curtilage means the area surrounding a dwelling that is necessary, convenient, and habitually used for family purposes and for those activities associated with the sanctity of a person's home. So basically the definition I just shared with all of you. Now notice it says the area surrounding a dwelling. It also helpfully defines dwelling. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporary or permanent, mobile or immobile, that has a roof over it, including a tent, and is designed for or capable of use by people. Fairly straightforward, and makes explicit that a porch is included as part of the dwelling, as part of the castle. So what does curtilage give you? Let's see. Oh, then they have a definition of residence. That's what I also wanted to cover. Residence means a dwelling in which a person resides, either temporary or permanently, or is visiting as an invited guest, or any dwelling, building, or other appurtenance within the curtilage of the residence. So appurtenance would be any kind of physical structure that's involved in the use of the home. Could be a detached garage in this context, or a tool shed, for example. See if there was anything else here. Now, those were the two references in the Tennessee statute I wanted to cover with all of you. All right. So that's curtilage in Tennessee and decks and garages. Let's go on to the next question. Make a note of the timestamp. Jack says, actually, I wanted to pull something else up here. Let's see. Did I already do that? Yes. Jack says, I've been taught that burglary required force. So before we get into the rest of Jack's questions, there are conditions that have to be met, that have to exist before you're privileged to use deadly force in self-defense. And the traditional self-defense conditions are these 5 elements of self-defense that we talk about all the time: innocence, imminence, proportionality, avoidance, and reasonableness. By the way, you can get this cheat sheet for free at lawofselfdefense.com/elements. It's just a PDF download. We don't charge a penny for this. It lists the 5 elements, provides a brief description of each. But often states will say, well, in addition to, if those 5 elements are met, those required elements of self-defense are met, we will also allow for the use of deadly force under other specific circumstances, one of which is commonly burglary. So burglary can privilege you to use deadly defensive force without compelling you to have to raise these elements. But that begs the question, if burglary raises the privilege to use deadly defensive force, what is burglary? How do you know if someone's committing a burglary? So that's really what Jack is asking here. I've been taught that burglary required force. You had to open a door. If the door was wide open and you walked in, that's not burglary, but I cannot find that in the law. Yeah, because that's not, I don't believe I've ever seen that as a condition of burglary. Now he's in Texas. So let's take a look at the Texas burglary statute. A person commits an offense of burglary if, without the effective consent of the owner, and I'm just going to do this part here, he enters a building or habitation and commits or attempts to commit a felony, theft, or an assault. So anyone who enters a building without the effective consent of the owner with the purpose or attempt to commit a theft, a mere theft, which, depending on the value of the property, could just be a misdemeanor, is committing the act of burglary under Texas law. That could be a house. It could be a building, a commercial building, but not open to the public when it's closed, perhaps. It could be a tool shed, could qualify. Does a person have to successfully steal something? No. And many states will define their burglary statute as no attempt is even required. In intent, you entered unlawfully with an intent to steal. That's the burglary. In fact, if we look at, for example, the Georgia burglary statute, (16.711), burglary in the second degree. A person commits the offense of burglary in the second degree when, without authority and with the intent to commit a theft therein, enters or remains within an occupied, unoccupied, or vacant building, structure, railroad car, watercraft, or aircraft. So again, if they enter a tool shed with the intent to commit a theft, that's second degree burglary, which is a felony. Good for up to, the first offense is good for up to 5 years. Do they have to successfully steal something? Do they have to walk out of the building with property that they've stolen? No. Nope. The entering without permission with the intent to steal qualifies as burglary under Georgia law. This, of course, came up in the Ahmaud Arbery case, the jogger case, when Ahmaud Arbery was killed fleeing from a home under construction that neighbors had seen him enter. They knew the homeowner. They had reason to believe, and stuff had been stolen from the house before, so they had reason to believe that this was a burglary in progress, that this stranger to their neighborhood, someone they didn't know, entered without permission with the intent to steal. And they sought to make a citizen's arrest of Ahmaud Arbery on the basis. And one of the conditions for citizen's arrest is someone in flight from a felony. Well, did they reasonably perceive that Ahmaud Arbery was in flight from a felony? Well, if they perceived the burglary, even just in the second degree, that would qualify as a felony. That would justify the citizen's arrest. But it's not required that something be broken to enter. Going in through an open doorway would be sufficient. Enters or remains doesn't say anything about having to open a door or not. That's not a requirement of the crime, an element of the crime. Jack also asks about this Texas statute, 30.02. Let's see. There's this first form of burglary. Enters a habitation or a building or any portion of a building not then open to the public with the intent to commit a theft. Well, this might be someone who goes into a large, like a Target, for example, or a Kmart or a Walmart. And of course, there are parts of the building that are open to the public, but there are parts that are not, right? There's the kind of the warehouse portion in the back of the store with the swinging doors. It says employees only. You're not committing burglary if you're in the portion of the store open to the public and you steal something. That's just petty theft. That's shoplifting. But if you go into the back space that's labeled employees only with the intent, or you make an attempt to steal, or here it says just intent is enough for this form of burglary, with the intent to commit a theft, you have now committed burglary. The question can be, it's sometimes ambiguous about, are you or are you not in a portion of the building not then open to the public? For example, if you're in a small shop and there's a counter and you are physically able to go behind the counter, normally we know that you don't do that, right? Behind the counter is the space for the employees. But maybe it's not labeled as such. Maybe you will argue that you didn't know that was a portion of the building that was not open to the public. You thought it was okay for you to go behind that counter and steal something. Well, if it's a portion of the building open to the public and you steal something, it's just shoplifting. If it's a portion of the store that ought not be considered open to the public, then you're committing burglary, a felony, instead of a misdemeanor theft. And it can be ambiguous. Stores might put up signs to kind of remove that ambiguity so they can ask for the more serious charge should somebody go behind the counter and steal something. But otherwise, it's going to be a judgment call made by a judge, a prosecutor, or jury as to whether or not your theft occurred under the circumstances in which you were in a portion of the building not open to the public. And that answer could be different in different trials, different juries, different judges, different prosecutors. When does looting become a burglary that would justify shooting? So it's not just one dude unlawfully entering with the intent to steal. It's a dozen people unlawfully entering with intent to steal. They're engaged in the act of looting. Well, that also meets the conditions for burglary. We do run into practical considerations, right? Because it's hard to defend yourself against a mob of people, even if you have a pistol. So tactically, it can get much more complicated than dealing with a single burglar. But the looting fits all the definitions of burglary. And in fact, in my opinion, should be an aggravated form of burglary. Okay, I think that's everything I wanted to touch on there. And yes, if there's looting going on and you use your gun and maybe you used it lawfully, does that mean that you're not going to get arrested and prosecuted and perhaps convicted, even though you were within the bounds of the law? And I would just point to Kyle Rittenhouse. I mean, it was obvious from the video. And of course, now we have the acquittal in court that Kyle Rittenhouse was doing nothing wrong. He acted lawfully when he was carrying the rifle around and when he was using the rifle to defend himself. But he still got arrested, prosecuted, and could well have been convicted. So that's another risk, right? Once you go hands-on in the fight, you've just incurred the tactical risk of dying in the fight and the legal risk of being prosecuted and convicted and spending much of the rest of your life in prison. Okay. Carrie asks about defense of others. If you come upon two people having a physical confrontation already in progress and one pulls out a gun and attempts to shoot the other, since you don't know which one was the initial aggressor in the fight, what should you do? You may be shooting the non-aggressor who decided to escalate the fight by pulling out a gun in a non-deadly force threat against the true initial aggressor. But you wouldn't know that for sure. Since the threat is now imminent, would you be acting reasonably in self-defense by shooting the armed person who is attempting to use deadly force against another person who appears to be unarmed? Yeah, that's a great question. And there's no black and white answer, unfortunately, especially if you did not see the start of the fight. So the law that would apply here is, in effect, when you come to the defense of another person, you're allowed to use the same amount of force in that other person's defense as they would be privileged to use themselves. So if they're being unlawfully attacked with a deadly force threat and they would be privileged to use deadly force on their own behalf, you're privileged to use deadly force for them. What if you're mistaken? What if it turns out that they were reaching for a knife in their belt and you didn't see that? All you saw was the other fellow whip out a pistol and be about to shoot them. So you draw your gun and shoot the guy with the pistol, believing that he had unlawfully escalated a non-deadly force fight to a deadly force fight. He had become the deadly force unlawful aggressor in the confrontation. But in fact, it was the other fellow who escalated to deadly force by reaching for his knife. And the guy with the pistol, who you shot dead, was simply defending himself with his gun against a deadly force attack. So you misperceived what was going on and took an innocent person's life. The legal question would be, well, was your misperception a reasonable one based on what you knew, the circumstances of the fight? It might be. It might not be. I mean, for example, if you didn't see how the fight started, right? You turned the corner and they were already hands-on. Is there any reasonable way for you to know who was the initial aggressor? I would suggest a good argument could be made that unless you saw the start of the fight, you can't have a reasonable perception of who's the initial aggressor in the confrontation. You might argue, well, I turned the corner. There was only a non-deadly force fight going on, and I didn't know who was the initial aggressor in that non-deadly force fight. But when it escalated to deadly force, when I saw the gun, I had a mistaken but reasonable perception that the guy with the gun was now an unlawful deadly force aggressor, so I used deadly force in defense of the other party. And that could work. That's the argument I would make. But anytime you see a reference to reasonableness, and here it's reasonable perception, remember that's a judgment call being made by other people, not by you. It's not your view of reasonableness that controls the legal outcome of your case. It's the perception of reasonableness by the prosecutor, by the police, by the judge, by the jury. And it's their perception of reasonableness, whether or not your perceptions, decisions, actions were reasonable. It's their perception of whether that was reasonable that determines your fate, whether you spend the rest of your life in prison. Is there any way for you to know if their perception of reasonableness is going to line up with yours at the time you're in the fight? No, there's no guarantee of that. So in fact, it leaves always available as a target of attack for a prosecutor the argument that you were being unreasonable and therefore it was not lawful self-defense. 3 minutes, folks. 3 minutes until we cut off the public streams. Become a Law of Self-Defense member right now for 99 cents. lawofselfdefense.com/trial, or scan that QR code so you'll be emailed how to stay with us for the rest of the show. Okay. So is there a short one I can answer in the next 3 minutes? There is a short one. Don had asked, going out of order, but Don had asked, how does the law apply in reference to the recent death of a hockey player during a game? In the video of this event, it appears that a player intentionally lifts his leg to strike another player in the neck with his skate. All the players should know that skates are a potentially deadly weapon. This being during a sporting event, does it change how this player may be charged and prosecuted? So I did cover that case, folks. I did a whole show on it. I probably did it after this question was posted. If you go to if you're a Law Self-Defense member and you go to lawofselfdefense.com/hockey, you can access my analysis there. And the guy who threw the skate to the neck, so the player hit in the neck died from having his carotid cut. The player who kicked him in the neck with the skate has now been charged, I believe, with manslaughter. So there is a criminal prosecution taking place. How does the fact that it's a sporting event affect the legal analysis here? After all, it's hockey, right? Hockey's a rough sport. Well, if you're playing hockey, you've effectively consented to other players using force on you to the extent that the force is a normal part of playing hockey. So you're going to get checked. You're going to get, occasionally struck with a stick, I guess, whatever they do in hockey. I've never played hockey. But clearly you're consenting to the use of force against you, and every other player is consenting to your use of force against them within the limits of what's normal for the sport. So you can't whip out a gun and shoot another player. He didn't consent to that. That's not part of hockey. And arguably, if this kick was intentional, which of course will be a fact to be argued in court, or reckless or negligent or whatever, no player is consenting to having a skate driven across his neck. Now, if it was a genuine accident, well, accidents happen in hockey, and then there ought be no legal liability for this unfortunate death. If it was negligent, well, you're not consenting to negligence when you're playing hockey, so there'd be civil liability for a wrongful death suit. If it was reckless, you're not consenting to recklessness, so that would be some form of manslaughter. If it was intentional, you'd be looking at some form of murder. because no one playing hockey is consenting to a skate being put intentionally across their neck, obviously. All right. And that, folks, that is it. That is it for the public portion of today's show. So again, if you want to stay with us, you need to be not there, here, lawofselfdefense.com/trial, and you can sign up. So I have a little video to play here while I end the public stream of the show. If you're watching as a member on the live stream on the member dashboard, don't go anywhere. In about 20 seconds, we will continue with the show. For all of you, your streams, if you're on Rumble, YouTube, or Twitter, your streams will be ending within the next 20 seconds. Have a great weekend.